So Simon, you have a fairly unique perspective on the subject of this book, The Law and Business of Litigation Finance. You're now special counsel at international law firm Cadwalader, but you previously, of course, worked with me here at Woodsford, and so you've seen both sides of the funder litigation lawyer part of the process. From that perspective, what do you think has been the reason for the growth of litigation funding over the last 10 years?
Yes, I think there's a mixture of factors that have led to what can really only be described as an exponential growth in litigation finance and its use in recent years, made up of both legislative and regulatory factors and also market factors. In the 90s, legislative reform in the UK really paved the way for embracing litigation funding in England quite early on, and then judicial acceptance began to grow from that point and has really only grown. Then in terms of regulation, the Ministry of Justice has allowed a essentially light touch approach through self-regulation of funders via the Association of Litigation Funders here in London, which has been very successful. I think then more recently, the introduction of collective proceedings on an opt-out basis in the Competition Appeal Tribunal after changes to the Consumer Rights Act in 2015 made access to justice available to consumers for breaches of competition law on a collective opt-out basis, which has driven growth of litigation funding in funding those claims which can really only be progressed if they're funded.
Yeah, and I think there's one issue that you haven't yet touched on, which is people like you, lawyers in private practice now, who really understand litigation funding and know how to take advantage of it for their clients.
Absolutely, I think that's one of the market factors is that awareness of funding has grown more generally, but also through people moving between funders and law firms, and it's now quite widely appreciated by lawyers that litigation finance isn't only a tool that's used by impecunious claimants who can't afford to bring litigation. It's a positive choice made now by claimants and lawyers alike, and lawyers in particular can use litigation finance as a tool to enable them to keep up in an increasingly competitive legal market by offering more innovative fee structures, enabling them to free up capital for other uses that they might not be able to do. And I think those are significant factors that have driven the growth in funding over the last few years.
Absolutely. And one of the chapter that you've contributed to the book, together with Zachary Krug, looks at the subject of privilege and confidentiality. So when lawyers discuss their clients' cases with litigation funders, is privilege really something they need to be worried about?
I don't think it's something that they need to be unduly concerned about by virtue simply of the fact that there is a funder involved. But obviously, lawyers and claimants should always be careful that they are protecting their client's privilege and confidentiality to the fullest extent available. Some defendants, when they learn of the existence of funding arrangements, may look to obtain a tactical advantage through instigating satellite litigation, seeking to obtain a tactical advantage through gaining advice that's been shared with funders by gaining copies of funding communications or documents in the hope that they're revelatory of a claimant's strategy. And the increasing popularity of funding, I think, is leading to a slightly wider spread use of those types of application. However, the law in England is pretty clear that privileged material, so for example, advices that have been shared by the lawyers with funders, can be shared without waiving privilege, as long as they're shared in confidential circumstances to a limited audience for a limited purpose.
Yeah.
And the cases in the US and the UK are aligned on that.
Yeah, and you have, of course, a transatlantic perspective. As much as anything, you're in the London office of a US headquartered firm, and the book takes a transatlantic view of litigation finance. What do you think, in a nutshell, are the key differences between the US and the UK on the issue of litigation finance?
I think one of the key differences is the way in which litigation finance has grown in the UK and the US. As I have said, in the UK, legislative reform quite early on allowed a sort of friendly environment for funding, whereas in the States that wasn't historically the case. The path hasn't been so smooth. There was greater resistance from lawmakers, from lobbying groups, including the Senate Judiciary Committee, the New York City Bar, Chamber of Commerce for Legal Reform in the US, and there's a lack of uniformity, both in terms of regulation of maintenance and champagny, ethical rules across the states, which hasn't made it such an easy environment for funders to grow into. Therefore, the market has remained slightly smaller, I think, than the UK. But it's not that it's not developing as quickly, it's just that it's developing a step behind. And now a lot of those challenges are being overcome, and acceptance of funding is now fairly common across the states. Mm-hmm. I think it's only set to grow because, as far as I see it from a funder's perspective, the US is an incredibly attractive market. It's a large market, a litigious one, and it's one that's attractive for funders from the perspective of limited adverse cost risk and also limited security for cost concerns.
Yeah. Well, listen, Simon, thank you again for your contribution to the book. It was fascinating to read.
My pleasure.
I look forward to seeing it in print.
Thanks, Stephen.